But very
Sunu, iPad this.
two of our convenience compilation. Compilation of documents in 35.
Para 15 can be taken from several compilations.
Para 15 is there. Data in your return submission, para 3.2.
And also para 9, Lordship may kindly see. Para 9 at page 5.
It will remain the same. Change. Para 15 will remain the same in all these compilations.
Correct.
The gloss on para 15 may change depending on what you're reading.
Depends how you
But the
look at,
original.
how you read and how you look at.
That's correct. Well, actually, I have the copyright.
All right, we'll read paragraph 15.
Now, see, when the commission is satisfied on information in its possession,
One minute.
is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. The Commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the Commission shall be binding on all such rival sections or groups. So let me, Millers, put forth a situation where there is no dispute as far as the legislature is concerned. There are factions within the party, each of them claiming to be that party. And without any reference to what's happened in the House, they go to the Election Commission and say, we are approved. Election Commission can decide.
1 minute. So.
Now let's see at what point in time does paragraph 15 operate? On the date when he files this application. It is 19th of July. Correct, Mullah? Can't be before that. Even if the election commission were to decide, it could only decide on 19th of July when he moves the election commission. But as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and he's voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority, then how do we move the election commission? And the election commission has no jurisdiction to decide whether he is a member or not. Para 15 will operate when both sides agree that they are members of the party. It has to be that way. Because he's claiming that I belong to a rival faction within the party. And he's claiming majority within the party. So where is the question, Malaks, of paragraph 15 operating at all in this case? Therefore, Malaks, to say that paragraph 15 is operative and is independent of all this, Malaks, with the greatest respect, Malaks, is contrary to very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The election commission of India will decide much later. The question
Yes. Mr. Zibal, what's the next point now? We've got this part of this limb of your arguments here.
Yeah, so therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there's a prima facie case. Surely, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, it would not be sitting here. 2, what's the balance of convenience today? That so far the election commission has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Yes. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court.
The court, this court's order.
Supreme Court.
Not the Bombay High Court.
No, there is no stay at all.
There is no stay of PMC election.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they have said.
When they produce the order, there is no stay.
The best of my knowledge,
Hold on.
there is no stay today.
The matter is coming up tomorrow in the High Court, and the state and Maharashtra Supreme before court number 2. State is asking for time of 2 weeks.
In the Bombay High Court.
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there is a chorus of
Dr. Singhvi, SLP?
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Wagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with it. My learned friends are thoroughly
It's totally wrong. The last PMC elections, the state came out with an amendment that was specifically challenged by us or directed status for my learned friend is not appearing in that matter, so he doesn't know.
No. I'm talking about the matter that's coming up in the High Court tomorrow.
As far as PMC elections are concerned, there is a status quo, my lord. That order we have placed, my lord, in our internal submission.
All right.
I'm just saying, Manoj,
That's for the balance of convenience. Sure.
But the matter tomorrow is about the OBC.
We'll hear you, Mr. Jetnani, we'll hear you. Let's follow some order. Yes. All right.
lot of enthusiasm moreover. That's all right. Normally, the point is, what's the balance of convenience? So far, it has continued. Matter is going to be decided by your lordship's Manoj, and it will determine, all the issues will be determined.
All right. So prima facie case and balance of convenience.
And then, Manoj, irreparable injury.
Yes.
Do not decide this matter and allow the election commission to go on, and the election commission freezes the symbol. What's going to happen? It's irreparable injury. Was to be. Without determining the issues that are pending before this court. And if those issues are decided in my favor, and you allow the election commission to proceed, see the consequences of that.
Yes, Mr. Sibal, we've made a note of that.
So,
Anything else, Mr. Sibal?
Don't take time without repetition. Very brief.
Who are you appearing for, Dr. Singhvi?
Because there are 8 petitions. I am appearing for the
All right.
Amendment
Yes.
parties, because we are on this side versus that side.
And you will be characteristically brief, Mr. Dr.
I am
Singhvi.
grateful for the word characteristic.
Correct.
Your Lordship has always rendered me speechless before I started. May I be very pointed. Your Lordships has 4 points in the 10th schedule. The issue is narrow. Whether your Lordships on a
Can you just formulate the 4 points?
Before I let me do that. Today your Lordship is not hearing the matter.
Right.
Today your Lordship is deciding the correct balance of convenience to endure till such time after Diwali your Lordship hears the matter and renders judgment. That's the only issue today. Now, for that, far from being unrelated, as the other side is saying, the issue is in direct collision and inextricably intertwined. That's the first point. I will demonstrate that in a minute.
Just a moment.
Direct collision and inextricably intertwined.
Yes, Dr.
Number 2, it is for that reason, and I'm not saying it's a judicial order, but it is for that reason that your Lordships has advisedly, in different combinations, from 4th of August 22, made it clear that people will seek adjournment in the election commission and the matter will not go on. There have been 3 dates in between from then to now, including one coming up later this week or next week. So it has been adjourned. That was the Lordship understanding. Of course, subject to the Lordship application today, no doubt.
Hilda's application was heard.
Number 3, why this inextricable intertwining and collision was? There are 4 elements of the 10th schedule, which Mr. Simple has shown, but those need to be summarized. One is the phrase original political party.
Just a moment.
This phrase is very important. Political party, original political party. Now, I stopped at clause 4 of the 10th schedule. Till clause 4, if my counting is not wrong, this political party, original political party, has been used 8 times. 8 times. But there are many more. I'm just giving Lordship original political party, and sometimes they say political party in the same context. If your Lordship sees 1C without reading it, it's been read to your Lordship, but just keep it open with us. Then 21A, and these are hard, these are the operative provisions. then explanation. So 1C, 21A, then explanation A. I'm sorry, my apology, was 21B also. 21B also. 21A and 21B. Then explanation A, explanation B, I, double I, actually much more than 8 actually. You should look at the sub clauses. Then 2 bracket 2, then 4 bracket I, and many times in clause 4. Now, let's.
Interestingly, Dr. Singhvi, where does the expression original political party in 1C appear in the text of the 10th schedule?
Yes, yes.
Just as a matter of curiosity, I mean,
Yes.
nothing really would turn on this.
Well, it's when they say.
It's in 4. It's in 4. 4.
It's 4 in the merger.
Where is original political party merges with another?
The political party phrase in the other clauses means the same thing. I'll tell you in a minute why. Because the idea in a minute I'll come to it. It's the same concept. Now, Willis, this is directly would be an issue on a subsequent date before the election commission, even on their reading of the symbols order. I'm not accepting the application, etc. All that is separate. On their reading, the symbols order clause.
Dr. Singhvi, can you just formulate the 4 elements and then you can
Yes.
because
So
this help us in.
Yes. Number 2, of the 4 elements, the first is political party, the second, split, group, faction, all out permanently from 2003 WEF 1104. Permanently out. That was the big bullet's pain because you created an anti-defection law. It was circumvented so easily. Therefore, and we have not yet heard, Your Lordship not hearing the matter. If Your Lordship reads the statement of objects, it's very graphic to prevent precisely what is happening now. So, element number 2 of the 10th schedule, no form of split, group or faction. Because that is directly what the election commission has to do.
Right.
Directly. In a minute, I'll show you. Number 3.
Directly?
That is exactly what the election commission is asked to do in the symbols order.
Okay.
I'm just saying, Willis, it is suggested that Your Lordship is unrelated to issues. Hear this matter in November. Let the election commission go on. Because how unreal would that be? Kindly consider. How duplicative. How irreversible. Number 3. And the statement of objects when we come to the final hearing will show that. There is a necessary condition and then there is a sufficient condition in 10th schedule. It's a cumulative combination. Now it is common ground, I repeat, that the necessary condition may have happened, but the sufficient condition not alleged to have happened. What is the sufficient condition for this? You have to, inverted commas, not recognize, break away. And then, because now that there is no split, so more than 2/3 go. That means it's the new group. That group by itself makes no difference to the 10th schedule. Suppose, let me give an extreme case. Out of 100, 90 go. Or 75. Unless the second sufficient condition is cumulatively satisfied, that is irrelevant. That is the whole purpose of the amendment. They have to merge or declare by merger, create a new political party. But only merger is the sole defense. Just bear with me on clause 4 for a minute. Just this needs to be read. Clause 4. That was the whole idea of substituting merger for split. It is nobody's case that in whatever form Shiva Sena exists there, in our whatever factions, that it has merged with the BJP. Now, a member of a house shall not be disqualified under 2(1). That's the only defense. It's an exemption. You will not be disqualified if this happens. It's like an exemption. a member of a house shall not be disqualified under 2(1), where his original political party, the question Justice Chandra should ask, merges with another political party, and he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed after such merger, or have not accepted the merger and opted to function as a separate group. This will be for the balance 25 or 10 in my example. Because you've gone 75 have gone, 10 are left, 25 are left. And
So the people who remain after a merger,
right.
their entitlement to be legislators is not taken away.
Because
You are entitled to say, I don't form a part of the merger. I stay back and I continue with my own.
I'm very grateful, Manas. I'm very grateful. Because Manas, and quite right, it is not their fault. The remaining 10 can't be disqualified because 75 have gone with it. So that's a very logical. Now just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior to Rajaswa.
that's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, and may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. Now, my question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
How do they enter the door of the election commission? Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide majority by persons who, if they proceed, you will disqualify tomorrow. Well, can your lordship form any part of a majority if somebody is disqualified? You are deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently had to be disqualified. Well, it is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the balance of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, there is the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points.
Now,
So you go to the next point.
You just note one thing. Well, if you are, what happens? There is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena. So you don't merge. Had you merged and knocked at the doors, it would be a new political party, subject to numbers. You want the best of both the worlds. Who are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving a coach and four through this. And Wallace's fifth point is, this thing was enacted, Wallace, 15 years, 20 years after, on the Ayaram scourge, with a huge amount of discussion, and amended in 2003. We are talking of largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singhvi, you're right. Dr. Singhvi, you're right that the 10th schedule does not recognize who is the real who is the real party? Party A, they are the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No.
Well, it's-
The symbols order, who represents or who is the real party is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only difference is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
Two answers. One answer is that assuming it is so, I'm not conceding it, I'm just answering my lot two alternative points. That has to logically follow, not precede. It's the
See,
first
let me tell you what is really troubling is this.
Yes, yes.
The whole concept of disqualification is in relation to the House.
Yes.
All right. The jurisdiction of the Election Commission is to decide who represents the political party, right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election.
Two or three answers. I appreciate that.
Right? That, so that is an area where, there is a little bit of constitutional thought to be done.
Answer number one. The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by our lordships repeatedly, including the famous case of Saranja. That's answer number one. Your lordship should not be under an impression.
So your contention is that therefore, because your contention really is that because the legislative wing of the party is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be prevented, interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of.
I were educated to appear in the Election Commission in symbol order cases. What they issue.
Now compiling.
Just to give you
I just give one.
there are 3 or 4 answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. Your lordships had them taken out. It's called common convenience volume. Just 2 or 3 pages.
The
there
old
are
one.
old one.
Double one.
Common convenience volume. Old one.
ये क्या मेन पेपर बुक में है सर? हाँ.
Two or 3 things here.
What are you showing, Dr. Singh?
Yes. First,
So we don't get. I think it does. What exactly are you showing?
I am showing, Willis, in that volume, common compilation volume, the Election Commission notice at 698, page number. 1 minute. Yes, sir.
What is the date of that?
Election Commission is dated
Page 1853.
22nd July 2022.
1853.
22nd.
July 2022.
Dr. Singhvi, why don't you give us a PDF page?
That was meant for the main hearing, not for today. I tried to take a technical objection, so still that. Our training is still incomplete. That 22nd July. Now, Willis,
1853. Incidentally, for the record, it is page 1853 of the PDF pages.
185. Yeah, great.
Dr. Singhvi, at 12 sharp, we'll wrap up with your side. We'll give you another 5 minutes, and
Yes,
so that
I'll be very.
we'll just take a short break, a comfort break, and we'll return to hear the arguments of the respondents
So,
after.
Willis, let me be very pointed. Now, this page, which your lordship has got the PDF of, the notice itself, as in all election matters, the symbol matters of the Election Commission. See the last page, 702. I'm sorry, I'm not able to see. 3 pages later. The last but one paragraph.
1857.
Yes. Require, well, let's just see the top paragraph. Prior to the hearing of the 2 rival groups, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. That page I'm asking Lordship to underline. Now, let's very quickly, if your Lordship doesn't mind, going back to my page 684, which should be, Willis, about 10 pages out here. PDF page, no PDF. My learned opponents, Willis, filing in the EC is very revealing. What they file. That starts at my page 670.
Interestingly, both sides in their written submissions have referred to the pleadings of the other. What the other side, when you filed your pleadings, both of you didn't have an idea of this thing that is going to now happen here.
You have said anything very seriously wrong, but this is very interesting what they have said. Kindly see 684.
684.
Yes. It's para 23, small Roman 23. Right. It is submitted that the petitioner, now this is the petitioner, the other side, presently enjoys the support of 40 out of 55 MLAs of the Shiv Sena. This is directly another issue. There is no question of 40 out of 55 disqualified people. In the Maharashtra Assembly, a resolution dated 26th of June passed by 40 MLAs reaffirming their support and faith in the petitioner and the main leader is annexed. That's point.
But can the EC proceed on a demurrer that assuming that these 40 persons are not to be taken into account in determining who represents, which faction represents the Sena,
Then the petition
even so?
That petition can't be filed. So there's no such thing. The petition can't be filed because the approach is all details of organizational and legislative, and just these 2 pages later, 687.
687.
2 pages. Well, the filer, the approacher is Mr. Shinde. He's not a member of the Legislative Assembly. Is he not claiming on the basis of the listed assembly status?
Right. Page 687.
Now, 687, on the top fourth line, organizational and legislative wings of the party. Fourth line, para 9, on the top of the page. Then para 10, next para, fourth line, all layers of organization as well as legislative wings. I can multiply this now, my time is short, so please come to Sadiq Ali. The citation is 1972, volume 4 SCC. 1972, volume 4 SCC. 664.
Now, I think that is the
document my lord is reading has been filed by a sole person, Mr. Eknath Shinde, whose only
Right.
status is that of a supposed MLA of the Shiv Sena, is what I will say. Now, what else?
you are now reading Sadiq Ali.
Sadiq Ali, para
I think Sadiq Ali is part of the convenience
yes,
compilation.
page 14 of their convenience compilation, the other side, but your lordship will get it in so many forms.
Just give us a moment, Doctor.
Para 26 there is. As your lordship knows, this judgment has stood the test of time, even though it is
Election Commission.
predating all us.
Election Commission.
Yeah, I just saw it.
I'm getting. Well, I am only on the point that there is a huge overlap, direct interconnection. Your lordship is deciding.
Yes, Doctor. We've
That's
got
why
it.
I'm not concerned about the final merits.
Very
Your lordship is told that it's a North Pole, South Pole apart. It's two unrelated issues. That's what I'm objecting to. As if they're two unrelated issues. Now, just see what is in their complaint, in Mr. Shinde's status, in their pleadings, they say, I have so many MLAs, I have so many MLAs. Now read this judgment. An election commission says legislative organization. Now read the judgment, para 26.
Para 26.
26, which is at page 677. The figures found by the commission of the members of the two houses of parliament and of the state legislatures, as well as those of AICC members and delegates who supported Congress J, have not been shown to us to be incorrect. It is, in view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported by Congress J. That's why the same phrase is used in the notice of the Election Commission. Same phrase. As Congress is a democratic organization, the test of majority and numerical strength, in our opinion, is very valuable and relevant test. Then, well, they go on. Well, this is, of course, 68 is 15 years prior or 20 years prior to state schedule. Judgment is prior, but I'm at the moment of the judgment's own terms. Well, can you separate? Can you, you are told that this is unrelated issue. Then, also note para 29, the last 4 lines. majority millets of houses of parliament, and sum total of members of state legislature. Last two lines of para 29 to save time. Last two lines of para 29.
In any case.
Last two lines of 29.
In any case.
Three lines. Now, this third aspect, symbols order, which is very important to repeat, predates by 15, 20 years, 17 years, is premised upon not a disqualification situation. It is premised upon a dispute. Because we are one group, we have a fight. He says, I want the symbol, I say, I want the symbol. It never contemplated the penal consequence of him being disqualified or being disqualified. It did not even enter their mind.
Correct.
Therefore, this was premised on the legislative wing. The logically prior stage has to be the disqualification. That is logically prior. Number 4, Mills, your lordship uses this phrase, it has become a commonplace, but it is a lot of weight. Not when the Supreme Court uses it alone, even lower courts. What is the meaning of the subject to outcome? We just say it like that. Your lordship will find the iron case. Your lordship says that. The idea is, look, I'm putting you on warning. You will claim equities because I may ultimately hold this way or that way. Now, this is the hiatus between them is several months.
All right, Dr. Singhvi, thanks. Can we wrap up on this?
Yes, I'm done with this. Because I want to only say one thing, that your lordship fellows will keep in mind also this concept of voluntarily gives up. Voluntarily gives up is a very important phrase which your lordship finds in 2.1a, inter alia. How do you voluntarily give up? You voluntarily give up when you don't satisfy the conditions of a schedule. Suppose I expel you. Then, of course, you are not voluntarily giving. That's why I said, in actual reality of political life, expulsion is welcome sometimes. It is a welcome. But, if you do some activity which is subject to disqualification and you leave and you proclaim yourself as a separate group, but don't merge, you have voluntarily given up membership. But if you have given up membership, with greatest respect, how does para 15 apply? That too by the sole applicant before the election commission, Mr. Eknath Shinde, who's the sole applicant. There is no other application. Today, your lordships can always decide, but today, he is under a cloud, under the simple text of 2.1a.
All right, Dr. Singhvi, thank you very much. We'll just take a short break and we'll be back and we'll hear these.
Balance of convenience of lordship does not have any impression that your lordship has some imminence or urgency.
Mr. Sibal made the point. We saw the of those orders. We can just see those for a moment. That's all that we'll share.
That's a good question. It exists is what I'm saying.
All right.
We direct, there are 3 enough. We direct the parties.
All right.
Thank you.
Yes, yes, Mr. Paul.
Because I very briefly, as VCA, what was the background which led to this litigation starting, and then come to the specific points raised by Dr. Singh. Because around the third week of
Mr. Paul, you appear for.
Mr. Shinde and some of the legislators.
Yes. Yeah.
That's around the third week of June 2022. A hopeless minority of MLAs within the Shiv Sena decided to convene a meeting, appoint a new whip, remove Mr. Shinde, which they had no authority to do because they did not represent the majority at all. The same day, coming to know of it, the majority of the MLAs met and immediately nullified the appointment of the whip they had appointed, the removal of Mr. Shinde. I'm overwhelming majority. But simultaneously, what they did was, a day later, they said that we had convened a meeting on 22nd of June 2022 at 5 p.m. And since these MLAs did not attend it, they are all disqualified. And we, on the same day at 5 p.m., are given a notice. In the meantime, this happened on the 22nd. Before that, on the 21st, the majority faction had already issued a notice for the removal of the deputy speaker, which was pending. The deputy speaker, my lords, on 25th immediately gives a notice to our faction and says, give your reply against your disqualification, because the allegation is you did not attend the meeting as convened, and because you have not attended the meeting, you stand disqualified under 10 schedule. And gives us 2 days to file our replies. Now, this comes to be challenged on 27th of June 2022. Wherein this honorable court says that as an interim measure, time is granted till 12th of July 2022 to file our replies. Immediately after that, MLA's leader of the opposition meets the governor and asks for a floor test. It is at that stage, and the governor issues a communication to the then chief minister, directing him to face a floor test on 30th of June 2022. A writ is filed by Mr. Prabhu, who, according to us, was illegally appointed as the whip by a minority of the members in the Supreme Court. A direct 32 saying that the governor should be directed not to vote.
A writ under Article 32 by Mr. Prabhu.
Yes, not.
He was a whip since 2019. So
Sorry, Mr.
He was a whip since 2019.
I said we had removed him. I had said
Mr. Sunil Prabhu.
yes, we had removed him on 21st of June. I had said so when I was giving my of events. We had removed him, and you had removed Mr. Shinde, which we said was a wrongful removal as minority. That's what I said. Now, my lords, so they find
writ
a
under
direct.
32 is by Mr. Prabhu.
That's saying that no floor test should be held.
Yes.
In view of the fact that disqualification of 42 MLAs is pending. Arguments for over 3 hours are held in the matter, and ultimately the court says that, look, in view of the law as laid down, as we cited, the court has said floor test, if at all, should be held at the earliest. And we said, why should you shy away from a floor test? You can't today say because a disqualification is pending, the floor test should not take place, because there are judgments of your lodges to say, even if a disqualification of an MLA is pending, he is allowed to vote in a trust vote, he is allowed to vote on a floor test, he is allowed to vote on the disqualification of a speaker or a deputy speaker. The proceedings and the function of the House cannot be stalled merely because the disqualification is pending. And those are your lordship's judgments on the point, on the issue squarely. And given the fact that floor test is the surest way to determine who actually enjoys the majority in the House, if at all a chief minister is confident enough, he should be more than eager to clear the floor test rather than evade and escape and run away from a floor test. So the court said, and directly said, we do not find any ground to stay convening of the special session. Now, my lords, immediately after that order comes, on the very same day, that evening, when the order is pronounced,
What's the date of that order?
29th of June 2022.
Yes.
On the same day, Mr. Thackeray resigns as the chief minister. Mr. Shinde and Mr. Padnase approach the governor, stake a claim to form the government. Mr. Shinde is sworn in as the chief minister. Then after that, the speaker is appointed. The speaker proves it because they ultimately again challenge the speaker's again appointment and Mr. Shinde's appointment. The speaker is overwhelmingly voted and confidence is reposed. And these are the facts which ultimately led to their all-inclusive one petition which comes to be filed where this IA has. I'm running through some of the other facts which may not be so relevant. So that's the broad background in which they now come up with an all-encompassing writ petition, saying that the decision of the governor to call Mr. Shinde to be sworn in, the floor test, of course, had become infructuous by then because the earlier writ petition, the chief minister had resigned. Then they say the speaker's appointment, etc., all illegal, and the Supreme Court should decide all these issues. Even before the speaker decides these issues, all of these proceedings should be transferred to the Supreme Court and they should be decided. There is no mention in the prayer clause or the writ petition about the Election Commission. In fact, there are categorical pleadings in the writ petition that the issue of who is the Ship Sena is the exclusive domain of the Election Commission. This is their writ petition, where they say the decision as to who is the Ship Sena is the domain of the Election Commission. Now, after that, my lords, we approached the Election Commission. The Election Commission, looking at the nature of representation that we make, say that clearly there are MLAs on this side, there are MLAs on that side, there are representatives on this side, there are representatives on that side. So obviously a dispute has arisen. And issues them notice to come and file a reply, place the relevant documents before the Election Commission to take a considered decision in the matter.
Mr. Kaul, where did they make this categorical argument that decision should be of?
Yes. Page 8 of our convenience compilation, ground D. That petition was filed on 8th of July 2022. But I'll come to the specifics later. So At that stage, when the Election Commission says, come and file the relevant documents before us, we have to proceed as a coordinate constitutional authority and exercise our jurisdiction to see who represents, because this is really an intra-party dispute. No one is saying, our case is not that we voluntarily given up the membership or we are splitting from the party. These are two rival factions within the party. So the EC said, we'll decide as to who represents the Shiv Sena. They come to the court and say, the EC should not be allowed to go ahead. The EC says, the Supreme Court says, we are giving you more time to go and seek time from the EC to file the documents. That request is again reiterated later, and the court again extends time to file documents before the EC. There is no order ever injuncted, and there was no notice issued in this IE to EC also. The order is go and seek more time to file documents. No injunction order ever passed. And ultimately, my lords, when your lordship passes the order of reference to a constitution bench, on the same day, an order is passed saying that the issue as raised in this IA will be considered by your lordships. So it is factually incorrect to say that on repeated orders of the Supreme Court, an injunction was being granted, or it was an understanding between the parties that the EC will not proceed with the matter.
Just give me the date on which the Election Commission issued the notice.
Yes, ma'am. 22nd of July, 22nd of July, 2022.
And what is the date of the order of the Supreme Court? No injunction, you said, but only time to file a...
Yes, yes. 4th August. It says, grants liberty to the petitioner to apply for extension of time before the Election Commission.
Yes.
Now, this is the background. And our respectful submission, of course, first is that this IA is beyond the writ petition itself. No substantive petition has been filed.
One short question. The letter of 1st of July 2022 issued by Shiv Sena Secretary for removal of R4, R10, R27 was made to the Election Commission. You will get it 360.
Yes.
So they wrote a letter to the Election Commission saying that we have removed them from the political party. Am I right?
Yes.
Yes.
And even
earlier,
in June, they had written a letter to the Election Commission informing that they had taken the decision there.
And not expelled from the party, removed from the post.
Correct.
Just not
removed from post.
Position, removed from the position of
Thank
leader in the party setup.
My lord, so all that I'm saying is, and I'll now summarize what my points in the law is. The law today is laid down by your lordships on a number of these issues as sought to be now canvassed is no longer recent. One is, my lords, your lordships have categorically held that the jurisdiction of the speaker, when examined under the 10th schedule, is to exercise his power to determine disqualification in the House. The Speaker cannot embark upon, those are the words used by the Supreme Court, the Speaker cannot embark upon deciding a split or a merger within a political party. Secondly, what your lordships have held is that,
except with one caveat, Mr. Kaur, that the whole concept of a split now is alien to the 10th schedule. That's one. Therefore, the reason why the speaker can't decide as to whether there was a split is because the 10th schedule now obliterates this concept, effaces the concept of a split. On merger, perhaps you may not be right because merger is expressly a defense under the 10th schedule, under clause 4. Therefore, whether there has been a merger or otherwise may possibly fall within the ambit.
I'll show some of the other provisions also will still be in the context of the legislature party, not the
that point you have made. That is the concept.
Your lordships were absolutely right in what your lordships are saying. My submission on merger is only that the speaker's jurisdiction is on the legislature part. That part of subclause 4 of 10th schedule was not read out to your lordships. I'll just read that. Secondly, my lords, your lordships have held that even where the symbols order does not predicate a particular situation or deal with a particular situation, the Election Commission of India, exercising its expansive and the words used are plenitude of plenary powers under Article 324 of the Constitution, is well within its rights to deal with any situation that arises. That is not to say for a minute that I am canvassing that under clause 15 or clause 18 of the symbols order, the Election Commission does not have the adequate power to deal with the situation like that. I'm going a step forward. Even in 15 and 18 were inadequate to deal with the situation that we are dealing with. Your lordships have said the plenary powers are enough for the Election Commission to deal with any such situation. But here, categorically, 15 deals with two rival factions within the party. And 18 covers situations which the Supreme Court has interpreted as interim directions or other orders which may be passed in the interest of justice. And your lordships in Sadiq Ali, while in detail dealing with the symbols order, categorically first dealt with the issue that a situation arises of two rival factions within a party. 15 is squarely the provision which sufficiently empowers the Election Commission of India to deal with it. And then Sadiq Ali proceeded to say that while considering it, both the legislative majority and the political majority will be looked at. But that is the Election Commission of India. A constitution bench of this court has already said that while the speaker decides the 10th issue, 10th schedule, jurisdiction of disqualification, he can't get into the political party because the very nature of the dispute is such, as my lords pointed out today at the start of the hearing, 1.5 lakh, 50 lakh representations by us. Zilla Pramukhs, talukas, district officers. Evidence is there. The powers, as your lordship knows, have been vested, and the power, and the Supreme Court has said powers of the state, powers of the court on the Election Commission of India. That is the alternative adjudicatory machinery created to deal with each of these issues.
Only thing, Mr. Paul, the genesis of the entire dispute, I think that's really the sense of the submission, that the genesis of the entire disputes arises from what happens on the floor of the House. Right? Absent what happens on the floor of the House, everything else wouldn't have taken place. That's their contention. Now, if that is so, then the issue as to what happens, the symbols order predates the 10th schedule. Sadiq Ali predates the 10th schedule, right? Because Sadiq Ali, in fact, Justice Hegde Grover and Justice Khanna.
That's
Now, Sadiq Ali predates the 10th schedule. Therefore, when Sadiq Ali speaks of the powers of the EC to determine both the legislative and the organizational majority, that the former part, namely its authority to decide the legislative majority, was at a time when the 10th schedule was not in operation. Now, does the fact that the determination of whether or not a disqualification has taken place is now exclusively entrusted to the Speaker, does that to that extent dilute the authority of the EC? And if so, then what is the impact of that decision which is entrusted to the Speaker? That is, I think, what they were really driving at.
So, Manoj, firstly, post Sadiq Ali also, and I'll show those judgments if there have been judgments.
No, we've seen those judgments. We just formulate the point.
Post Sadiq Ali also, which have talked about the interplay of 10th schedule, symbols order. There is nothing to suggest. There is nothing to suggest that any way does the 10th schedule dilute the exercise of jurisdiction under the symbols order 1. We, my lords, the constitution bench of this court categorically says that when you embark upon this inquiry, it is restricted to majority in the House. Because the very nature of inquiry that we are talking about, where a political party is completely beyond the machinery provided for the Speaker or the powers vested in the Speaker. And that is why that whole line of judgments, my lord, where your lordship said powers of the state, powers of the court, all vested in the Election Commission of India. Detailed evidence. Now, will the Speaker get into interacting with every taluka pramukh, every district officer, every president of every area, the registered membership of the party? It doesn't get into all that. There is no machinery for it. That's not the intent. And if your lordship sees everywhere in the 10th schedule, political party in a context and then followed by legislature party, as your lordship pointed out, including clause 4 of 10th schedule. And it is interpreting that a constitution bench of this court says that when you embark upon the journey of deciding on disqualification from a house, don't mistake this for a power to decide the larger political issue or division in the political party, which is there. And I tell your lordship, because inherently it can't be done by the Speaker. And there is nothing today in this matter, my lords, nothing at all as far as the pending petitions are concerned, whose outcome in any way will impact what is pending before the Election Commission of India and take their case at the highest. That we will all be disqualified as members of the House. I take their case, that's the maximum that can happen, my lords, that we are disqualified as members of the House. Does that stop us? Does that stop us from going to the Election Commission as a member of a political party to claim that we represent or we are the Shiv Sena?
But suppose you were to argue on a demurrer, assume for a moment that the person who has moved the EC is disqualified. All right, for a moment, on a demurrer. Does that disqualification of the person who has moved the EC impact upon either his locus or the authority of the EC to determine who really represents, which of the two factions represents the party?
So Manu, that's a very pertinent question. Let me So, my lords, the question that my lords put to me, let me give your lordships two stages which can happen. One is what happens, what is happening here, and the other is what your lordships put. One is that disqualification petitions are pending. The Supreme Court has told the Speaker on their request not to, in the meantime, take any decision on those because the Supreme Court was seized of the matter as far as the Speaker's exercise of jurisdiction is concerned. And pending those petitions for disqualification, can an MLA or an MP be prohibited from approaching the election commission? Your lordships in any number of judgments have said that even when disqualification petitions are pending, an MLA and an MP is well within his rights to participate on the proceedings of the House. Vote, exercise all that is vested in and under the Constitution.
So until he is disqualified, the consequences don't attach at all.
Absolutely,
That's the rationale for it.
One, and including my lords,
Yes.
including the line of reasoning that your lordships took
Yes.
in Nabam Revia, that
Yes.
that if a deputy speaker or a speaker of membership, that he can always proceed in a direction where his own disqualification, that was another link, would be accordingly impacted. So till I am disqualified, I continue to be a member to participate all its vigor and robustness in the proceedings of the House.
At page 359, that very question. This is a letter written by Uddhav Thackeray to Eknath Shinde saying that you have been indulging in anti-party activities and have also voluntarily given up your membership in Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So this doesn't affect his primary membership. If his primary membership is actually affected, then he can't maintain a petition before the election commission. That's perhaps their argument.
Yes.
So therefore, at the threshold, election commission cannot maintain a petition on his behalf. But it is, if it is not affecting the primary membership, it is only a post he continues to be a member of the political party, then he can perhaps file.
And my lord, just to add to what your lordships are saying, this is their contention that I have given up my whole cases. Who says I have given up the membership voluntarily?
That is yet to be considered.
That is yet to be considered. My whole case is that a set of 14 MLAs decide that I am removing something and overwhelming majority is on one side. You take a unilateral decision with a hopeless minority and then say, I've disqualified you or you voluntarily given up a membership. We have repeatedly said that we are the Shiv Sena, whether it's in the Lok Sabha or it's at the Legislative Assembly. We represent an overwhelming majority within the party. We've never said we've left the party or we need to merge with someone under 4 to be protected. We have right through said that whatever actions a set of people who were in a hopeless minority took have no sanctity of law, are unsupported by any legal provision at all, and you could not have done, you did it without authority. So with such emphaticness, when it is said that you voluntarily gave up the membership of the party, who will decide this? Because you say I've given up voluntarily the member under 10 schedule, or will the speaker decide it under the 10 schedule? Because your lordships have held that the power of the speaker and the decision of the speaker under clause 6 of the 10th schedule is final on these matters. And that decision is still pending. My lords, was the question that your lordships put to me, that suppose a person, now this is the first case where no decision has been taken, the issue is pending. The other is I am actually disqualified and I incur the wrath of Schedule 10 of the Constitution by whatever action there's a decision of the speaker against. That still does not, as my lord said, deny me the primary membership of the political party. I'm still entitled to approach the election commission for whatever grievances I make.
That you have said, so that you are not removed as a member of
Yes.
the party. You may be removed, correct, disqualified as a member of the legislative party.
And now, my lords, they sought to rely on Sadiq Ali to say that, look, both the words legislative and organizational majority have been referred to in Sadiq Ali. Now, organizational and legislative majority is referred to in Sadiq Ali from the perspective of the EC deciding, not from the perspective of the speaker embarking on an inquiry as to who represents a majority in the political party. Then they relied, my lords, on to say that this will have a bearing on the matter because a judgment of this court said, and I'll read out in what context the judgment was when I come to the case law, to say that any disqualification ex post facto relates back to the date when you were disqualified. And thus, if they were disqualified on that date, that's the end of the matter. Quite apart from the fact that even if I was disqualified, it doesn't stop me from going to the EC. But the reason the Supreme Court said ex post facto, and there are other paras that I need to show, was this, because that was a case of a BSP government in Uttar Pradesh. A decision was taken to dissolve the assembly. The cabinet decision was yet to be communicated. I'm just very briefly giving. 13 MLAs of the BSP went to the Samajwadi Party and said, stake a claim to form the government. Because these 13 MLAs went to the Samajwadi side to stake a government, Mr. Maurya at that stage made a petition to the speaker saying that this is an overt act on part of 13 MLAs to show that they have voluntarily given up the membership of the party and thus they ought to be disqualified. So the speaker was seized of this issue of disqualification of MLAs as on that date because 13 MLAs had gone to the Samajwadi Party side. In the meantime, another 24 MLAs joined the 13 MLAs and they claimed that there has been a split in the party. Now the speaker went ahead and decided the issue of a legitimate slip with 24 joining 13 and did not decide the issue of disqualification, which Mr. Maurya prior in time had directed, saying that your very act of going and seeking support from the Samajwadi Party amounts to giving up an anti-party activity, voluntarily giving up membership. In that context, the Supreme Court said, as far as exercise of powers by the speaker is concerned, this disqualification will relate back to the date when the speaker was required to exercise the jurisdiction and the speaker could not have decided on the split within a party without deciding their original disqualification from the House, which stood there. It is in that context that the word ex post facto was used. And I'll show those two specific paras. The same judgment, my lords, the Supreme Court then goes on to say that you as the speaker can't embark upon and decide within a political party what happens. Your lens is only the lens of a legislature party that you have to see it. And inherently, my lord, the proposition which is sought to be forwarded will be impossible to implement. A, the Constitution doesn't say so. B, practically and inherently, it's impossible if you expect the speaker to get into these issues of lakhs and lakhs of memberships across the country without the necessary adjudicatory machinery.
So according to you, both the powers are different. Jurisdiction under both the powers are different. Correct? And the inquiry under both are different.
Completely different. If at all, my lords, if at all, a finding of the EC may help speaker, if at all, but nothing that the speaker decides will ever impact a member approaching the election commission. So to say that the two petitions are intertwined, thus this must await the decision in the main matter, is completely wrong. Now, my lords, even as far as that one question which is referred to, which is the last question, J, which I just...
Scope of powers of the EC with respect
My lords,
to
all that is, I'm very clear. What is the scope of powers of the Election Commission of India with respect to determination of a split within a party? No one has questioned the vires of the symbols order has already been upheld by your lordships. No one has ever questioned the power of the Election Commission. All that has been said herein is the scope of the powers of the Election Commission. Now, if I were to accept the argument as sought to be forwarded by the petitioners, my lords, then till the Constitution Bench of this court decides on the scope of powers of the Election Commission. This may be the Shinde versus Thakre matter, but there could be another matter where there are disqualifications of MLAs and another set of people go to the Election Commission. So the Election Commission is denuded of its powers as a coordinate constitutional authority to continue and do what it is mandated under the Constitution to do, because your lordships are seized of the question of the scope of the Election Commission. This is one matter, my lords. All that has been said, court in its wisdom thought that the scope of the powers needs to be looked into. My respectful submission would be, my lords, even the scope of the powers divorce the symbols order in the light of judgment of your lordships is expansive and plenary. But the symbols order itself under clause 15 and 18 specifically provides for a situation like ours, which is rival factions within a party, interim directions to be given. And my lords, your lordships in any number of judgments again have held that pendency of disputes does not bar the Election Commission from issuing any interim direction which it feels is necessary in the interest of justice in the meantime. Now, another argument raised was, what happens if the Election Commission suddenly freezes the symbol? Who will be able to contest? There will be mayhem, there will be chaos. What will happen? Now, my lords, your lordships have also held that you are entitled, if you represent the overwhelming majority, whatever you think you represent the overwhelming majority within the party, to go and say that we are entitled to represent the party and use the symbol. That's your legal right. Symbol is otherwise not the property of an MLA. It's the decision of the Election Commission. But I have a legal right to claim that I can use it. That's one that I can do in this matter. Presuming, suppose a situation were to arise in the court and the Election Commission was to come to a conclusion, no, we can't decide. There are orders, where freezing orders have been passed by Election Commission, and in the intervening period, temporary symbols have been given. Those are not jurisdictions of Election Commission to decide. You today in a 32 want the court to be seized of the matter, exercise the jurisdiction of the Speaker as a court of first instance, exercise the powers of an Election Commission under a 32, and none of these constitutional bodies should be.
Yes,
My lords, I have two judgments to show to you.
Which are those judgments?
One is, my lords, the Rana judgment. Other is Sadiq Ali. And third is Pananis.
Right. So we give you about 5 minutes after lunch.
Yes. My lords, just.
Yes. On the days, my Lord the Chief Justice indicated on the days when the Constitution Bench sits, the Constitution Bench runs for the whole day. So we continue.
We'll continue.
Yes. Well, I just require 15 minutes from your Lord, because I need to show 3 judgments and some provisions.
Indulgence, a brief supplement by me and Mr. Singh.
10,
10 minutes each.
Right after Mr.
Paul finishes.
Paul finishes,
Just a
maybe
brief.
5 or 10 minutes
10 minutes,
between the two of you,
Right
and then
above.
we want to hear Mr. Data
Yes,
because
yes.
he's preparing for a constitution body.
Most important.
Question number F.
Yes,
Or the referred questions. Question number F is, what is the scope of the election commission?
that's
J.
J. We'd like to hear Mr. Data. We do, of course, since we are appearing for party, we hear on this side as well. But we want to hear Mr. Data.
Yes, my lords, I'll finish with it. Very
you.